Well, Henshaw again on your Constitutional Cook channel on YouTube and other places. And I'll do a little bit different one today because I've been talking to a lot of people who've been following my videos, know how I explain how we can go in there and beat the bastards, especially in traffic courts, or as I've done, criminal courts, or you name it. And family law courts you can include in the list too. I'm going to be looking for people that have a lot of problems with there, and there's a lot of problems to sort out in family courts. Trust me. But I'm here to tell you, not only can we do that, but we can then, in fact, we can do it with a lot of my issues that are unopposed. And I have constitutional issues emanating from all 6 articles of the Constitution for the United States. You almost never see them, especially in this day and age, in any of these courts. That's a great thing for us because that means they're novel questions which have a greater chance of getting reviewed. And the way I do things, we have a right to be in the U.S. Supreme Court. It's not discretionary. This is from their own mouths saying it. Send me an email and request info on my materials at uwinnincourt@gmail.com. I'll send you information on that and some quotes and some documents that you're going to love. One of them is from Cohen's v. Virginia, 200-year-old case, and they just recently, in this term, recited it in support of the claim of Texas in the case of Texas v. California. I've done some videos on that too. And you look at that and you say, well, what does the Constitution say? Well, Texas tried to file papers there against California. Um, and I think it had to do with the Affordable Care Act, but that's irrelevant for the moment. But what does the Constitution say? Article 3, Section 2, in all cases, A-double-L, in which the state shall be a party, the Supreme Court has original jurisdiction. That's mandatory. There's nothing voluntary about it. If they file, the court has to file the documents and at least hear the case and make a decision. Because otherwise, Texas has nowhere to go. None of the states have anywhere to go. And the great news for us, as I've been saying on earlier videos, is that we have better standing than states do. Think about that. It has to be because didn't we create this Constitution and create all the states to it? I mean, my goodness. There are agents. Principals have more standing than agents. And I think that's the reality that's beginning to sink in with the 9/0 parts at the end of this very contentious term, especially with the Biden court packing plan, about which more later, and some other ongoing matters of strong interest to us constitutional coups. So that said, what we do is you file documents, and I've never, ever had any documents in the decades I've been doing it even acknowledged, let alone answered by the local dumbass. And they have the burden of proof to sustain, on the jurisdiction and venue of the trial court, and they can't do it. And that's why they don't even attempt it, because to do so on the record will expose the fact that that jurisdiction doesn't exist and subject any and all of these official bastards to personal liability for acts of treason, exactly like the Supreme Court said in Cohen's, and like what they just said in what looks like a two-justice dissent in the case of Texas v. California. But trust me, that's exactly the opposite of what it looks like. So we're in a great unprecedented period of time where we can do it. And even better, the threat of filing a suit like this after we go through some preliminary steps is going to be so strong, even in their corrupt courts, if we have to go there. And trust me, I don't think we'll have to do that. But if we do, I can beat them there. That's how good I am. Use their own damn laws against them. But they can't be sure of the outcome. And one win on the record, especially with the 9/0 parts, binding case law from Portland, Maine to Portland, Oregon. Now we get somewhere. Now we get some rights we can enforce. And now they're going to have to start obeying their sworn oath to be bound by this Constitution and the laws enacted in pursuance thereof. Article 6, Section 2. That's what the Constitution has to say about that. And it damn well should be that way. And if we can't enforce those oaths, why have them? Makes no sense, does it? So that's where we are at this point. It's exciting. There's going to be a little work for you to do, no question about that. But you get my document packets. It explains it in very easy terms. And you concentrate on just a few of the documents at first when you get them. I'll tell you all about that. Send me an email, uwinnincourt@gmail.com, and we'll get you all the information out on that and explain to you what I'm doing to set the unopposed record. And I've got one that's almost 800 pages in my South Carolina case, and about the same in an Oakland case in which I'm collaborating. And in the Oakland case, the damn DA was just like they always are, very, condescending, and demeaning at the start of the case. But they're the ones that decided not to go to trial when they realized they couldn't have me on the witness stand as an expert witness on the Constitution, because I would have woke the jury up in a hurry and have great credibility. And when you do a little studying on your own, so will you. You'll be able to do the same thing. You don't have to be near as good as I am, because the ignorance on the other side is palpable. I mean, it's astounding. People who've been 4 to 6 years of law school don't know a damn thing, because it isn't taught anymore and hasn't been in 90 years, maybe more than that. So that's the good position that we are in here, and we can get some big things done. And some of these big settlements, we're going to be making changes in the way they do business too, so it doesn't happen to anybody else. That for me is the main thing. That's why we're going to have a lot of credibility in front of a jury that we are never going to see. They can't have that happen. All they got there is their damn attorneys in their $2,000 Dior suits, dripping money from every pore of their bodies. That's all they're there for. We're not. It's going to be a damn good chunk of change. Don't misunderstand me here. But we're there to make changes, and changes that will positively affect the members of the jury and their families and their posterity. That's why you should want to do this. You can set an example for your kids, for your posterity. We can challenge the bastards and beat them. This is the only nation ever conceived in which I think that's ever been possible. It still is if the Constitution remains in full force and effect. And as I've discussed on recent videos with the Supreme Court, I think they're finally coming to terms with that, and that they have to start doing their job for the first time in 150 years in order to save the Republican form of government of defined and limited powers set up by the framers. Anybody that talks about things being good for the democracy, run, don't walk to the nearest exit. My first law school teacher, almost 40 years ago, had a very succinct definition of democracy: 3 wolves, 2 sheep, voting on what's for dinner. That's all it is. That's all elections are. And when you get my material, send me an email, uwinnincourt@gmail.com. Among other things, you're going to learn there are no elections. None. I can prove every bit of it. If that's true when we get in front of a jury, how the hell is the local dumbass or the persecutor or prosecutor going to show consent of the governed? Can't be done, hasn't even been attempted. That's what's so exciting here. And we can maybe turn your case around quick too, because there isn't going to be litigation. They can't have that go, even into one of their corrupt courts, because these type of issues come out and become public. It's going to wake a lot of people up. Even with what I call the misogynistic mainstream media is going to get wind of this. And there's some real issues here that can be very difficult, if not impossible, to overlook given the magnitude of the issues. I mean, you go in there saying, for example, that California is not a state admitted into this union, you better damn well be able to prove it. And with my information on my document package, you're going to get the first 5 pages of my 83-page brief on that subject. Not me saying it. I say it with attitude and with authority, and you can do the same thing by using my documents in your cases with my full support, behind you to support you in your efforts. We can do it. So what have we got? No states, no jury, no right to counsel, no 14th Amendment, no Republican form of government. I mean, it goes on and on. All 6 articles of the Constitution. I think it's not too late to get it all back. And with the Supreme Court apparently behind us with the Texas v. California case, and what looks, as I said, on paper like 2 dissenters, but it's exactly the opposite. That's good old CIA language for you. Black is white. But they realize that with the Trump justices in particular, not a well-known quantity yet, they want to keep a low profile and see what happens with Biden and with the election recount and some other things that are going on. So that said, send me an email for information. I'll get it right out to you. youwinningcourt@gmail.com. Subscribe, like the videos, tell your friends, get the word out. We all have to work together. If we do that, Asians, Africans, and Americans, and knock off this divide and conquer BS they've been doing for at least 150 years, we get there that much quicker and get these bastards off our backs. Thank you.